Hello, welcome to today's webcast. My name is Bruce Carton. I'm the editor of Securities Docket, and I'll be hosting today's webcast, which is brought to you by Securities Docket and our sponsors today, Ankara Consulting. Ankara is an independent global expert services and advisory firm that delivers services and end-to-end solutions to help clients at critical inflection points related to conflict, crisis, performance, risk, strategy, and transformation. The team consists of more than 2,000 professionals serving more than 3,000 clients across 55 countries who are leaders in their respective fields and areas of expertise. Today's webcast will be on corporate guardians, trends and considerations affecting gatekeeper liability. And our guests today are Sean Franzblau of Venable, Abby Peluso of Riley Safer, Chris Stetler of Catton, and our moderator today, Colin Flood of Ankara. Before we hear from our guests, let me quickly go over the agenda for today. We are scheduled to go for about an hour. I'm going to give a very brief introduction, and then we'll jump right into the presentation. We welcome your questions. Your questions are anonymous. Don't hesitate to ask any question you may have. To ask a question, just click on the questions box at the top and type your question in, and we'll try to answer as many as we can. You can also view the webcast in a full screen mode. There's an icon on the bottom right-hand corner, which will allow you to see everything a little bit bigger. All right, let me quickly introduce our panelists, and I'll be brief with the intros. All of the bios are available on the attachments tab, so you can check out their full bios and contact information there. We start with Colin Flood, a senior managing director at Ankara, and our moderator today. He's based in Chicago, has nearly 2 decades of forensic accounting investigation and corporate compliance experience, and has conducted investigations and other work in over 45 countries, and was previously a senior executive at a Big Four accounting firm. Thanks for joining us, Colin.
Thank you, Bruce.
Next, Sean Franzblau, a partner at Venable. He's also based in Chicago, a former supervisory attorney at the U.S. Attorney's Office for the Northern District of Illinois, where he served for nearly 11 years. Sean represents clients in government enforcement, defense, internal investigations, and other complex litigation matters. Welcome, Sean.
Great to be here. Thanks.
Next, please introduce Abby Peluso, a partner at Riley Safer. She's based in Chicago. She previously served as an AUSA in the Northern District of Illinois in both the civil and criminal divisions. And her practice focuses on government enforcement actions, internal and external investigations, and white-collar criminal matters. Great to have you with us, Abby. Thank you.
Hi, thank you so much.
Finally, very pleased to introduce Chris Stetler, a partner at Catton. Chris is based in Chicago. He served for over a decade as an AUSA, including as deputy chief of the General Crime Section. His practice focuses on white-collar defense, internal investigations and compliance, and complex commercial litigation. Chris, welcome, and thanks for joining us.
Thanks so much, Bruce.
All right, I'm very pleased to have everybody join us today. And Colin, let me turn it over to you.
Great. Well, thank you, Bruce, and thank you to the Securities Docket for hosting this webcast today. Welcome, everyone. We are very glad you've joined us for a discussion on a topic that is very relevant and important today, particularly given how regulators have been increasingly focused on holding individuals accountable for their part in corporate misconduct. By way of we have seen, by way of example, through public statements by senior officials at DOJ, SEC, and from results of enforcement actions, that gatekeepers within organizations and external to it remain a significant focus for prosecutors and staff at the Commission. I'll moderate our discussion today, and I'm joined by a wonderful panel of attorneys, each of whom have had long careers as former federal prosecutors, and will have great insights to share in the important role that gatekeepers play to protect organizations from financial and reputational harm. Looking at our agenda for today, we have a packed agenda, and we'll start with the basics. What are gatekeepers? What are their roles and expectations within organizations, as well as what parties are traditionally considered external gatekeepers to an organization. We'll cover the regulator's perspective and the emphasis that regulators have historically had on holding individuals accountable, and in particular gatekeepers. We'll highlight a few key trends and unpack a few interesting cases involving gatekeeper liability, and we'll share perspective on the available guidance from regulators to mitigate gatekeeper risk. And finally, we'll close our discussion with thoughts on best practices with a focus on compliance officers. So with that, let me turn to Abby, if I may, for our first question to kind of set the table for our overall dialogue. Abby, broadly speaking, one might think of a traditional gatekeeper, say, as an auditor, an accountant, an attorney. But really, that definition, though it's broad, can be quite nuanced, right? And include other roles within an organization. If you could please share your perspective, what is a gatekeeper? Who are they? And what are the general expectations of gatekeepers?
Sure. Thank you so much, Colin. So kind of big picture and in the context of legal liability in particular, whether that's involving the commission, investor suits, or other individual criminal or civil liability, a gatekeeper really is anyone who stands on the front line of compliance with rules, regulations, ethical obligations, and the law. And so while the categories that you pointed out, auditors, attorneys, accountants, are sort of traditionally thought of as gatekeepers, as we'll talk about this morning, it really can be anyone with specialized knowledge or skill who's tasked with advising corporate leadership or companies regarding compliance in any sector. And so Sean, I think, will discuss this in a little more detail as our discussion continues. But that can include people like a chief information technology officer, a CFO, a chief compliance officer, a CISO, really anyone who's in charge of keeping tabs on rules and regulations, and then ensuring that the company is operating within those rules or reporting on compliance, either internally to the company or externally to the commission, to investors, to the public, to the government in general. And so within an organization, they can be people who hold those positions or consult on compliance, or they can be outside of the organization as well. And Colin, you mentioned an auditor. An auditor is kind of the classic example of someone who's exercising objective, impartial judgment on issues encompassing compliance in various departments. And of course, on that issue, on what the expectations are for an outside auditor, those are complicated, but they're also enumerated at a very high level. They're specific and expected to be objective and impartial on those issues. But other outside consultants, people who are retained for the purposes of providing advice or counsel, could be considered gatekeepers as well. That could include, attorneys, outside counsel, outside accountants. So anyone with that kind of specialized experience and knowledge hired to provide compliance-related advice or counsel, whether inside or outside of the corporation.
Great. Thank you, Abby. That's great. And I'd be curious, from your experience, how does the DOJ and SEC think about gatekeepers? Because we've seen from press releases from the commission, they tend to take a very broad view of gatekeepers. Like, for example, they reference professionals who share responsibility for protecting investors and who play critical roles in the capital markets. Could you unpack that a bit? Is there anything more there that we should be thinking about in terms of how the regulators think about who's a gatekeeper?
Yeah, and I think Sean and Chris will have some things to say about this topic too as we continue. But at the end of the day, the federal government, whether it's the Department of Justice, the SEC, in criminal and in civil cases, are focused on individual accountability. And that's been true for years. That's nothing particularly new. And I think that the core of that and the core of our discussion today is pretty simple, meaning that misstatements to the commission, right, those are made by people. False and fraudulent statements to investors are made by people. Crimes are committed by people. Wholesale failures that Sean will discuss to perform duties and expectations of the job are done by people. And so where those people are the ones that are responsible for ensuring compliance with the rules, and they are engaged in fraudulent activity, they're engaged in affirmatively misleading investors, the commission, the federal government, or they're engaged in these sort of wholesale failures to do their job, they could be held personally responsible. And that's something that directors at both the Department of Justice and the SEC, that bipartisan administrations have emphasized, is department priority to hold those individuals accountable. And so as we'll sort of be discussing throughout the morning today or the afternoon today, the best way to mitigate that risk is to be proactive, to evaluate the strength of compliance programs and make good faith efforts to comply with the law.
That's great. No, thank you. Appreciate that. And Sean, if I could come to you next with the next question here, as we think about all the advances in technology that we've seen and frankly, even the evolving threat landscape that organizations face from bad actors, organized criminals, it would seem that the notion of who's considered a gatekeeper or first line responsible for protecting an organization may be evolving. And Abby kind of touched on this. It could be inclusive of corporate executives, perhaps, that are maybe the chief information and technology officer, right, from a cyber risk perspective. I'd be curious your perspective. Is the category of who's considered a gatekeeper, is that changing or expanding based on, say, advances in technology or the overall increased kind of threat landscape from bad actors? How should we think about that?
Yeah, it is changing and expanding. And I think Abby had it exactly right. I like the way she defined gatekeeper as basically anyone with a specialized set of knowledge or skills who advises corporate decision makers on compliance issues. And, as technology continues to advance, companies are becoming increasingly reliant upon machines and algorithms to perform core operational functions. And in many instances, your traditional corporate leadership, be it the board or the executives, may not have a deep understanding of these technologies, both how they actually work or the full set of, compliance implications in adopting them. And so they've become increasingly reliant upon technological subject matter experts to advise them in key areas of compliance. And so, yes, these technical subject matter experts are increasingly coming into the fold of what we think of as gatekeepers. And I think that the two biggest areas to highlight here are artificial intelligence and cybersecurity. Starting with artificial intelligence, over the past 2 or 3 years, there's just been an explosion of companies spending tens of billions of dollars investing to adopt and implement advanced AI systems, whether it's generative AI, deep learning models, to perform, core analytical, creative, and decision-making functions. Even AI experts don't understand how many of these advanced systems actually work, how they get to the output they get to, but they are generally going to have a fuller understanding and appreciation of the compliance, the ethical, the operational implications of adopting these technologies. And so we see companies, as they adopt these technologies, they are also increasingly hiring or creating new positions to oversee them. So things like chief AI officers or creating AI governance boards. And these positions are comprised of technical experts largely to advise corporate decision makers on how to manage the risks associated with these technologies. And so, yes, these AI experts are going to be increasingly treated as gatekeepers, as this, first line of defense concept that when we think about gatekeepers. And the Justice Department has recently signaled that with recent revisions to its evaluation of corporate compliance program ECCP guidelines. I think we're going to talk more about that later, so I'll put a pin on that for now. Shifting to cybersecurity, this has obviously been a major focus for a while now, but there are a few things that can do more widespread damage to a company's operations and value than a sophisticated cyber attack. So, regulators are and have been for a while now laser focused on making sure that companies are adequately addressing these risks. With the SEC's new cyber disclosure rules, not so new, from 2023, an example of the increasing focus on that. And we see sort of a double-edged sword with the technological advances, because as the technology improves, the defenses get better, but the threat actors also get more sophisticated. And so we're seeing things now like deep fake attacks, where like executives are being impersonated, deep fake settings to authorize company payments, things like that. So CISOs, chief information security officers, are taking on an increasingly important gatekeeping and compliance role within the companies. And again, that's not really new, but certainly since the SolarWinds case was charged, there can really be no question that CISOs are squarely with the gatekeeping category. And I expect that, that will only continue. And I think we'll talk more about the SolarWinds case a little later.
Yeah, great. And Sean, just to unpack the kind of liability piece of it, obviously, regulators are focused on individual accountability. It's more important than ever for gatekeepers to be aware of their own risk exposure, personal liability. Can you just comment on what type of action or even lack of action by gatekeepers could potentially trigger liability for them?
Yeah. So Abby touched on this. There's really kind of three types of liability we're talking about here, and we're talking about individual liability. There's criminal liability that's coming from the Justice Department. There's civil regulatory enforcement mostly from the SEC, and there's also private civil suits, coming from folks like investors or creditors, actions that are brought against gatekeepers in certain contexts. So those are kind of the types of liability. In terms of the conduct or lack of conduct that can expose gatekeepers to liability, I kind of generally think of it as falling into two categories: active misconduct and passive misconduct. And within the active misconduct bucket, there's also kind of two subtypes. We see that, first, there's misconduct that relates to the gatekeeper function. So these are, gatekeepers who are committing bad acts in their role and as part of the scope of their responsibilities as gatekeepers. This usually involves things like misleading regulators or investors. It can also include obstructive or cover-up conduct after the fact. Going back to the SolarWinds case, the allegations in that case are an example of this. The allegations were that the CISO of this software company, SolarWinds, knowingly made misleading statements to both investors and the SEC regarding the strength and capabilities of SolarWinds cybersecurity systems, and also the associated risks that cyber attacks pose to the company. Actually, most allegations in that case have been dismissed, but there's still a one big claim remaining against both the company and the CISO. But another classic example of active misconduct within the scope of gatekeeper responsibilities would be like an attorney providing a bogus opinion letter to facilitate an unregistered securities offering. For example, falsely opining that the offering meets one of the SEC's registration exemptions. Another classic example would be an outside auditor, knowingly signing off on a false financial statement or a financial statement that does not comply with GAAP standards. That's then later, included in the 10K report. So that's kind of the first type of active misconduct we see. The second type is active misconduct that does not relate to the gatekeeper function, but it's committed by someone in a gatekeeper position. A classic example of this is insider trading by corporate executives. Again, this is really just kind of fraud or other types of crime that are being committed by people who happen to be, in gatekeeper positions, but the crime itself does not relate to their gatekeeper functions. And it's actually in this category that we most frequently see criminal charges. A couple recent examples out of the Southern District of New York, on-track case. There was a parallel DOJ criminal and SEC civil proceeding against the CEO of a publicly traded healthcare company. The CEO and the company were convicted last summer. Another case called the Archegos case, where a CEO and CFO were charged criminally and by the SEC in basically a market manipulation, pumping up the stock scheme. Again, it's kind of confusing to think about those as gatekeeper liability, because it's really just crime committed by people in hold a lot of responsibility within companies, but it's often referred to as gatekeeper liability. The second big category, so active misconduct, is passive misconduct, and these are generally cases of extreme negligence, basically across the board dropping of the ball with respect to your gatekeeper responsibilities. So an example of this might be a chief compliance officer who, develops a reasonable compliance program on paper, but just totally fails to implement it. No employee training, no, real mechanisms in place for reporting misconduct up the chain, doesn't consistently investigate whistleblower complaints, whatever it is. The compliance program is basically window dressing, and there's nothing being done to actually implement it. The last point I want to make in this area is that, one thing we are not seeing, and one really important takeaway, is that good faith efforts that do not end up turning out well are not prosecuted, are not charged. Basically, as long as gatekeepers are acting reasonably and diligently with the information that they have at the time, the DOJ and the SEC are generally not going to second guess you. That might be the most important takeaway of today's presentation. I know that, there may be some gatekeepers watching today who get a little nervous when, we start talking about individual liability. But, a key thing to remember is that the Justice Department and the SEC, they're trying to enlist gatekeepers. They're sort of outsourcing the, detection and enforcement responsibilities, and they sort of need to have an alliance with gatekeepers. And if, gatekeeper liability extends into second guessing good faith efforts or kind of Monday morning quarterbacking with the benefit of hindsight, you're going to start scaring off good people from filling these. That is definitely not what they want to do. So, generally speaking, if you are, trying to do your job well, reasonably diligent, you're not going to fall into the crosshairs of the DOJ or the SEC.
Yeah, no, that's great, Sean. And that's a great point you made there towards the end. I mean, that's particularly, I think, relevant and helpful. Chris, if I could just pivot and turn to you next with this next question. Obviously, focus on gatekeepers is very relevant today, but it's not a new thing. It's not a new priority for regulators, right? There's been a historical track record of emphasis around gatekeepers. I'd be curious your perspective on, why does the government, why they so keenly focused on it now, but also just kind of comment on the historical landscape of a focus around gatekeepers historically.
Sure. Well, I think the government has always been interested in getting the biggest bang for its buck. I think we've all heard references to the government having endless resources. But what most of us have seen is that the government's resources are actually limited. So the government needs to make priorities just like any other organization. And it makes sense for the government to target people who are going to provide the largest deterrent effect to other people. So there's a focus on going after people who are more sophisticated or in more influential positions at larger companies. And whose job it is to prevent misconduct and promote good conduct. And at least in the government's view, gatekeepers fit that profile. I think in reality, the picture is a lot more complex. Just as the government has flaws and makes mistakes, companies have flaws. Gatekeepers don't have a complete picture. They're operating in a fast-moving environment with limited resources and all sorts of imperfect systems. And rooting out wrongdoing is difficult. There's just no way to prevent all forms of wrongdoing within large organizations. But the government is certainly doing everything it can to get companies to prevent corporate wrongdoing, and targeting gatekeepers is one way of doing that. I think the government views gatekeepers is people who, in a sense, Abby and Sean refer to this as helping the government pursue its mission of rooting out wrongdoing and promoting positive cultures within organizations. I think both SEC and DOJ officials have described gatekeepers as being key members of teams meant to prevent wrongdoing, and even the first line of defense. So the government tends to view gatekeepers involved in wrongdoing as more culpable, and that's for a number of reasons. In the government's view, gatekeepers should essentially be the grown-ups in the room. They have the more influential positions, and they should be the ones to prevent rather than engage in wrongdoing. I think the government also believes that targeting someone like a gatekeeper will be more likely to attract media and other attention. And that's going to help publicize that there are consequences for misconduct and will potentially deter similar conduct. Taking an enforcement action against a gatekeeper, or even launching an investigation that touches on a gatekeeper, can cause change within a company and can cause companies both inside and outside the industry to make changes that the government wants. So I think gatekeeper liability is relevant today because the government is consistently raising the bar. The government's using a number of tools to crack down on corporate wrongdoing, and it certainly views gatekeepers as one of those tools. And I think, fair or not, that broad view isn't going to change anytime soon. So it's all the more important for companies to do what they can to put competent gatekeepers in important roles, and also with the right resources, so that those people can pursue their jobs, as Abby and Sean have mentioned a number of times, in good faith.
Yeah, that's great. Thank you, Sean. Appreciate that. If we just maybe now turn the discussion a bit to highlight a few recent cases. I know we touched on a few previously. Sean, you mentioned SolarWinds and some others, Abby as well. We've seen from the SEC, they released their Division of Enforcement results. I think it was back in November 22nd, on kind of the year in review of enforcement results. And there were a number of cases involving gatekeepers there. Sean, let me just come back to you if I could quickly. Are there any kind of key trends or any cases you want to highlight that you think would be particularly interesting for the audience to hear?
Yeah. Well, since we're all in Chicago, I'll start with the local one. Earlier this year, the SEC's office in Chicago charged an auditing firm called BF Borgers and its owner in connection with basically across-the-board failures to comply with PCAOB standards in its audits and reviews of public companies. It included allegations of both active and passive misconduct, to go back to my kind of the buckets that I think about. In terms of passive misconduct, they were charged with failing to supervise their auditing teams, failing to properly prepare and maintain basic auditing paperwork. But it actually went much further than that into active misconduct and actual, intentional fraud, that they were alleged to be falsifying records, saying that they were performing certain auditing work that was not actually performed, things of that nature. The case is notable for its scope. It ended up affecting over 1,500 SEC filings, hundreds of different publicly traded companies. It's also significant because of the penalties. To settle the case, the firm paid $12 million and the owner paid $2 million. And both the firm and the owner are barred under SEC Rule 102E from practicing the commission. That 102E is an important gatekeeping enforcement rule that the SEC cases like this. In terms of trends, I think Abby's going to talk about this more lately, but there's lots of action in the cryptocurrency space, which makes a lot of sense if you think about it. This is a massive trillion-dollar industry. It's been around for about 20 years now, and during that time, there's been lots of instability and fluctuations in the market, and there's also been massive failures in the market, FTX, Terra Luna, and others, and yet there's still no comprehensive, statutory or regulatory regime in place that's designed specifically for cryptocurrency. And so this idea of the first line of defense being out in the market itself, of the gatekeepers sort of policing themselves and policing the industry, is sort of takes on heightened importance, I think, in the cryptocurrency space. There are two interesting, there's actually several, but two I'll highlight here, gatekeeper cases arising from the fallout of the FTX debacle. One is that the SEC charged FTX's outside auditing firm, it's called Prager Metis, with basically negligence-based fraud for misrepresenting that its audits of FTX complied with GAAP standards. And specifically, the allegations are that in failing to, uphold those standards, the auditing firm basically failed to detect the risks associated with FTX's relationship with Alameda Research, which about the case. It's sort of the shifting of funds between those two entities that caused FTX to crash. In a separate action, the SEC charged Prager Metis with violations of auditor independence rules. They were basically including indemnification provisions in their engagement letters with various clients. So, I'm in the outside auditor. I engage with you, and I basically say, if I get in trouble for my audit, you indemnify me, you pay me back. That's a big no-no after, Enron and Sarbanes-Oxley. Auditor independence is a key enforcement priority. A few months ago, Prager Metis settled that case by paying about a $2 million fine to the SEC. And then the last case I wanted to highlight is a private lawsuit in which FTX's investors have sued Fenwick and West, the law firm, one of FTX's law firms, basically alleging that the firm participated in the fraud. There's actually two different actions. I think they've now been consolidated in Miami. But the allegations are that the law firm participated in the fraud basically by helping FTX to structure corporate entities and transactions in a way that allowed it to evade regulators. So those are two interesting actions against outside gatekeepers, the auditing firm and the law firm in the crypto space.
Great. Thank you, Sean. That was perfect. Abby, if I can just turn to you, any thoughts on trends or cases that you're seeing that you think would be important to bring to light?
Yeah, so I think Sean kind of covered the obvious trend with crypto and the lawsuits, particularly the private suits by investors related to failed companies or the fallout from a failure. But there are other sort of heightened risk areas. As we've been talking about, I think it's important to remember this theme, though. I have a partner at this firm who often says that with fraud and compliance investigations, a lot of times it's the same wine in a different bottle. And that's sort of how I've been thinking about preparing for today's discussion, because this idea of holding individuals accountable is something that the government has always done, right? When the Foreign Corrupt Practices Act or the FCPA was implemented, there were decades of investigations, and there still are, related to compliance with those requirements and certifications of those requirements, often by a gatekeeper. When those compliance measures failed, when they weren't properly executed or implemented, the gatekeeper that could then be found liable. Same thing with the False Claims Act, which is something that we haven't really talked about, but is a relevant consideration because certifications on all sorts of compliance are made during the acquisition of government contracting. And when those certifications are false, intentionally false, there can be liability against the company, and the gatekeeper could then be at least a critical witness in that particular investigation. But, to your question about 2024, what are we seeing as heightened areas of risk? One that we haven't talked about that I think is worth mentioning in the time that we have is that for regulated entities, including like broker, dealers, investment advisors, there's been sort of this sweep on failure to comply with record keeping requirements. You'll see those talked about as off-channel communication sweeps. And this is an important topic because, as Sean was saying, as technology evolves, as the advent of AI or other ways that people communicate, just applications that are available in the market, the way that people communicate, including for business purposes, has changed. And where that's gotten individuals in trouble and where it's gotten companies in trouble is when there's been a failure to sort of implement and execute protocols regarding the preservation of off-channel communications. And this goes back to Sean's point about that wholesale failure. It was talked about by the former executive director for the compliance division, Gray. Well, he said, look, all of these companies that are getting in trouble for off-channel communications actually have protocols about not using off-channel communications for the purposes of conducting business, particularly the financial sector, broker advisors, regulated entities that have particular data document preservation requirements. He said that there were over 40 firms and over $1.5 billion in civil penalties that had come from charges related to off-channel communication problems, and that every one of those firms had policies and procedures regarding those communications, but nevertheless, employees communicated through unapproved methods. And he noted that the gatekeepers there failed to implement the policies that the companies had in place, meaning that they did not properly train on those policies. They did not properly ensure execution of those policies, and often themselves were in violation of the policies. And so I think with regard to the financial sector, we're continuing to see that sweep. I think that this is something that will continue to be an area of focus for the commission, particularly for regulated entities, because communication channels are ever evolving. And so it's more the implementation of policies, making sure that there's, as Sean said, training, execution, real teeth to the protocols, and that they're not just compliance policies that live in a shelf somewhere, but that they're actually being implemented. And then, Sean talked about crypto. I think we've kind of covered that at a high level well enough, but auditors, lawyers, outside consultants have already found themselves sideways in private lawsuits with advisors, with the public, with the commission. And to the extent that any of those become regulated, I would assume that we would see more and more enforcement efforts.
Yeah, great. Thank you, Abby. Appreciate the kind of historical look back. And I'd be remiss if I didn't ask about kind of forward-looking point of view around, what we might anticipate next year under President-elect Trump's administration. I think certainly one can assume the enforcement agenda and set of priorities will look different, probably much different. But I'd be curious for the panel's view on what do you anticipate kind of going forward in relation to government enforcement of gatekeepers under the new administration. So maybe Chris, if I could start with you, and then Abby, Sean, if you don't mind commenting, but maybe Chris, if I could just start with you for a few minutes.
Sure. Well, I think we all know how predictable things are these days. So take this for what it's worth. I will speak to what I think are the consensus views on some things. I think we saw last week, Trump named his pick to lead the SEC, Paul Atkins, whom the Wall Street Journal described last week as the, quote, anti-Gensler. I think that might be just a bit strong, but I would expect the new chair to focus more on what have been the SEC's historical core mission and enforcement priorities. In terms of changes to specific areas, I think the new administration obviously is expected to take a less aggressive approach to crypto. During the campaign, President-elect Trump promised to end what he called the war on crypto. And Atkins is expected to be more crypto friendly than the current administration has made some public statements to that effect. We've seen with respect to crypto that markets are certainly responding. Bitcoin and other forms of crypto are surging in the markets, all with the expectation that there's going to be a change away from the regulation by enforcement approach taken by this administration. I think there also may be some changes to ESG. Atkins has criticized SEC requirements for companies to disclose ESG related information. At one point a few years ago, he stated, quote, mandating politicized corporate disclosures doesn't align with the SEC's mission to protect investors and facilitate capital formation, end quote. So I expect the new administration to take a dim view on ESG related actions. Abby mentioned off-channel communications. I think there's also speculation and an expectation that the next administration is going to take a less aggressive approach on that and some other violations that some view as kind of no harm type violations. I don't think this means that we're going to be returning to the Wild West, though. I don't see the government losing interest in an area that both Abby and Sean have mentioned, which has always been a priority, which is just old school fraud, misrepresentations, false statements. And just because the government may not prioritize certain areas, companies certainly need to be mindful of private lawsuits, reputational interests, and really importantly, company values. So I think those are the concerns that are always going to be relevant, even if the government is going to be prioritizing them.
Great. Thank you, Chris. It's great.
Yeah, I agree with all of that. I think that, however, we are still going to see a call for robust compliance programs at corporations. I see that as a perennial concern that isn't particularly political, that there will be continued emphasis on cybersecurity, especially around data access and controls, and that we will continue to see government expectations of robust cultures of compliance, which is something that the SEC and the Department of Justice has called for decades, and I expect that that will continue. I also think that, to Chris's point, most enforcement actions, whether they're through the SEC or certainly federal criminal charges, are grounded in affirmative misconduct. And even though we're talking about trends that come into the crosshairs on the wholesale failure bucket, the kind of passive failures that Sean categorized as such, I think the majority of enforcement actions and all federal criminal charges relate to affirmative misconduct, false statements to the government or to investors for the purposes of making a material misrepresentation to keep money or to do an end run around protocols. And I would expect to see no change in the priority of those areas for the incoming administration. Of course, it's hard to say anything with certainty, but I would be very surprised if anybody takes their foot off the pedal on those issues.
Great. That's helpful. Thank you.
Yeah, I agree with everything that's been said. Obviously, one area of major uncertainty is what the FBI is going to look like, what the leadership is going to look like, what structural reforms may or may not take place. That could obviously have a big impact on federal law enforcement across the board, but the FBI is typically, the lead agency for criminal investigations, investigating, corporate misconduct and white collar crime. So, depending on what goes on there, that could certainly have implications for enforcement against gatekeepers and corporate crime generally. The only other thing I'd mention is this idea of the Department of Government Efficiency having to cut $4 trillion. If you're not cutting Social Security, you're not cutting Medicare, and you're not cutting military spending, that doesn't leave that much of a pie left. So we could just see across the board cuts in other, areas of discretionary spending that could affect, federal law enforcement kind of across the board. So just a general observation there, but I definitely agree with Chris and Abby's more specific answers.
Great. Well, thank you. I appreciate that. And just recognizing that our audience today includes a number of gatekeepers in-house and even external, I think it'd be helpful to talk about some best practices and some of the things that we're seeing in your experiences that we can, share with the audience more broadly, and, kind of thinking specifically about compliance officers, the compliance function within an organization, to create and maintain an ethical culture, establish a commitment of integrity, implement an effective program, all key fundamental aspects of a compliance function. So, Chris, if I could just come back to you, kind of what are you seeing coming from regulators to provide guidance to gatekeepers on their increased responsibilities? It was mentioned earlier about the DOJ's, ECCP policy that came out recently, but kind of what guidance are you seeing coming from regulators? What are some best practices that you think would be helpful for gatekeepers to know and be aware of?
Sure. So just to kind of take a step back, regulators have certainly made clear that they're focused on wrongdoing within companies. Abby just spoke a little bit to this. I agree that will not change or is not expected to change. Regulators are doing essentially whatever they can to incentivize people to come forward with evidence of wrongdoing. And when we see regulators speak on panels or in the public, it usually takes them less than 30 seconds to use the phrase self-report. We're also seeing self-disclosure programs being rolled out around the country. There are also whistleblower programs that incentivize people to report wrongdoing. Ms. Collin, as you referenced a few months ago, DOJ updated its evaluation of corporate compliance programs. So with respect to self-disclosure programs that U.S. attorneys' offices around the country are introducing, there are some differences from office to office, but in general, people can avoid prosecution if they voluntarily report to the government previously unknown information and fully cooperate with the government's investigation. And then under the DOJ's new whistleblower program, individuals who report corporate wrongdoing can recover a portion of funds that are forfeited in a subsequent prosecution. There's a lot to say about changes to the evaluation of corporate compliance programs, which are about 25 pages of densely worded, single-spaced questions that can be asked to compliance officers. I just want to emphasize kind of a few things that were mentioned in the changes that were recently made. First, while the DOJ's evaluation factors are updated periodically, the focus is on having compliance programs that are well-defined, operated in good faith, and work in practice. So those are kind of the big picture factors for folks to consider. There's also always been an emphasis on updating compliance programs to adapt to changes, including with technology. So now companies are expected to better understand risks associated with those new technologies, including what is certainly in the news all the time now, namely AI. There's been emphasis on creating channels for reporting and rooting out wrongdoing. So you want to make sure that whistleblowers are protected, that people are trained on how to report and respond to reports of wrongdoing, that compliance officials have the tools needed to address issues rather than just having paper policies and nothing else, and that companies learn their lesson from past mistakes. It's certainly easier to learn from other companies' mistakes, so it can be effective to highlight in training or even in periodic internal communications some published enforcement actions against other companies within a certain industry. It's easy to get in the weeds on these things with compliance programs and some of the specifics, but I think it's important, as Sean mentioned kind of at the outset, to think big picture, use your common sense, promote a culture of doing the right thing, trust your instincts, and act in good faith. Government officials have cautioned people over the last several years to call us before we call you. And they're clearly creating all sorts of incentives for people to report wrongdoing outside their organizations by going directly to the government. Whether to self-report is a separate and fairly complex discussion, but as an initial matter, it's clearly in companies' interests to have programs to detect and prevent wrongdoing in the first place before losing control to an outside party and certainly to an enforcement agency. It's obviously better for a report to be made internally than externally to one of those enforcement agencies. So basically, you need to make sure that internal allegations are going to be investigated appropriately, and that as a result, people have faith in the organization to report internally. And compliance officers should be able to point to all of these government efforts in an attempt to get the resources they need to maintain effective compliance programs.
Great. Fantastic. Thank you, Chris. That's great. And Sean, I was wondering if I can come to you kind of more with a very specific question. You know, we've seen the DOJ has a certification requirement that came out of the Glencore resolution. It effectively requires CEOs and CEOs to certify that the corporation's post-enforcement compliance program has been reasonably designed to prevent violations. What have you seen? You know, what does that requirement really mean for CEOs in practice? I wonder if you can kind of elaborate on that a bit.
Yeah. So, beginning in, I think, late 2021 or early 2022, the DOJ began signaling through multiple channels that going forward, as part of any corporate resolution, it was going to start requiring CEOs and CCOs, Chief Compliance Officers, to sign the certification that the company's compliance program was reasonably designed and implemented to detect violations of law, and that it was functioning effectively. So that was going to now be part of any corporate resolution, whether it's pleading guilty or a deferred prosecution agreement, whatever it is. And then in May of 2022, we saw the first example of this with the Glencore case. Glencore was a multinational commodity trading company, pled guilty to conspiracy to violate the Foreign Corrupt Practices Act. Basically, it was an incredible case. One of Glencore's subsidiary companies bought and sold oil around the world, and for almost 25 years, Glencore paid about $100 million in bribes through various intermediaries to government officials in various oil-producing countries in Africa and South America in exchange for various business advantages. And so as part of the plea agreement, Glencore had to pay a fine of about $340 million. They had to agree to an independent monitorship. But additionally, the CEO and the CCO had to sign a certification that the company had implemented an anti-corruption compliance program that was reasonably designed to, prevent this from ever happening again, to detect and prevent future FCPA and other corruption-related violations. And, most significantly, I think, for purposes of our conversation about individual liability, is that the certification included a provision that stated that the certification constituted a material statement to the executive branch for purposes of 18 USC section 1001, which criminalizes, making materially false statements to federal officials, basically. And also that it constituted a record, document, or other tangible object in connection with the matter within the jurisdiction of the executive branch for purposes of 18 USC section 1519, which criminalizes falsifying or destroying records in a federal test. So, in some ways, this helps to kind of tee up the CEO and CCO for individual criminal liability in the event of future FCPA violations, right? They've certified that these statements are within the, reach of 1001 and 1519. Now, in practice, that would be very, very difficult prosecution to do, right? You would have to show that at the time the CEO and CCO signed the statement, they knew that it was false. But I think what's more important is the sort of the flip side of that, which is that no CEO and no CCO is going to sign something like that and expose themselves to individual criminal liability unless they are darn sure that they do have a reasonable compliance program in place that can, detect and prevent this kind of misconduct. And so, when the DOJ explains the purpose of this requirement, they say we're not trying to put a target on these people's backs. We're trying to empower them. And in that sense, I think there is something to that. A CCO is not going to sign that statement unless they are, in the room when it happens. If they're, they have to be included in the board meetings or the audit committee meetings or, whatever it is where these things are being discussed and these programs are being finalized and implemented. Otherwise, they're just not going to sign off on that. So I do think that, there is something to that it does empower the CCO in that respect. And as further proof of that, to date, no CEO or chief compliance officer has been criminally charged in connection with signing one of these certifications. It's a relatively new requirement, but we haven't seen that. And I frankly don't expect to see that for the reasons I just explained. Nevertheless, it's certainly caught the attention of these gatekeepers, CCOs in particular. And it underscores, I think, the Justice Department's general increased focus on compliance programs. Generally, that's been a major focus for the last couple of years. And so, I think the message is now is a great time to make sure that your house is in order with respect to your compliance program. It's a great time to review it with a critical eye, take steps to update it based on, lessons learned from things going on within your company or things you're seeing out in the market, in the industry generally, and in connection with the trends that we've been talking about, particularly, emerging technologies and AI. But, I do not think that this new requirement is deterring good people from wanting to become CCOs. I do not think that it is or should be keeping good CCOs up at night because, again, well, I'd love to tell you that everyone's exposed and you need to hire Chris, Abby, and I to help you. The truth is, as long as you are acting in good faith with reasonable diligence based on the information you have at the time, you are just not going to come into the crosshairs of the Justice Department and the SEC. It's not in their interest to over prosecute these cases. They need to enlist these folks to be on their team and an active part of that first line of defense.
Yeah. No, that's great, Sean. Thank you. And Abby, we have a few minutes left here. Just kind of coming back to you. Any thoughts on best practices you want to share from what you're seeing with your clients? Anything in the market that further empower gatekeepers to mitigate their own liability?
Yeah, and I think what Sean said is perfectly said, and that now is a good time to sort of get your house in order. And I'd call back to what the former director of enforcement said last year about what it is that gatekeepers can do to make sure that they sort of stay out of trouble. And he phrased it as education, engagement, and execution. I thought that was really well said. Education meaning know the landscape, do the research to know what are the regulatory and statutory and ethical obligations for your department, and what are the trains coming down the tracks? What is the government showing interest in? What are hotspots that are relevant to your business? And then invest in resources to make sure that your compliance program is robust and real. You know, if you're not getting the resources that you need, speak up about that. And when you're not getting it from the person that's directly above you, go above them, engage the board or the CEO if you need to make sure that you have the resources that you need to be in compliance. And then on, engagement and execution, Sean said it best, that the right people need to be in the room when the discussions are had, so that those conversations include all of the stakeholders. And then execution, which is kind of what I said earlier about the off-channel communication protocols. But compliance on paper is only as good as its execution. It needs to be rolled out. There needs to be trainings. People need to know when a rule is changed and what that means for them, top to bottom. And so I liked those kind of three talking points, and I can't say it better than Director Graywell, so I'll leave it at that.
Great. Thank you, Abby. And I know we're kind of coming up on time here, so I have been monitoring the Q&A channel throughout our dialogue, and we've touched on broadly all the questions that have come through, so thank you for the questions that the audience has posed. Also, feel free to reach back out to myself or one of the panelists if you have any further questions. But let me just take a quick moment to thank the panelists for a really terrific discussion. And just the great insights that you've shared. So really appreciate your time and the preparation put into this for today. Bruce, let me come back to you for any final remarks.
Thank you, Colin. That was terrific. Thanks so much for that update on this area. If the audience could just take a minute and click on the ratings button at the top and provide us with any feedback you may have, we'd really appreciate it. On behalf of Securities Docket, I want to thank everybody for joining us. I want to particularly thank our guests, Sean Franzblau, Abby Peluso, Chris Stetler, and Colin Flood. And a special thanks to Ankara for making the webcast possible. The webcast has been recorded. It'll be available as an archive shortly on Securities Docket. But that concludes the webcast. Thank to everybody, and we'll see you again soon.
Thanks so much.